Welcome back to another Jay Harris Academy of Police Training roll call. I'm Joey Sperlaza, joined with Colin Congleton. We are both case law instructors, and we want to go over an important concept for us to understand: the attenuation doctrine. The attenuation doctrine in New Jersey is affirmed with the state versus Marcellus Williams. And I think before we even get into that case, one of the things that we should break down is under Terry versus Ohio, the difference between the investigatory stop and the investigatory frisk. Those are two separate elements of every case that we deal with. The stop has to in itself be legal, and then we have to go a step further to show that this person is armed to be able to actually do a pat down for weapons. If you want to touch on the two prongs, Kyle.
Yeah, this is something a lot of officers have a tendency to misunderstand. So when we talk about the classic Terry stop and the issue of stop and frisk, uh, most of us are well aware that the Terry stop must be supported by reasonable, articulable suspicion, right? Uh, More so, you must be able to articulate that the person has committed, is committing, or is about to commit a specific crime, right? Now, that's going to be your justification for the stop, the Terry stop. But in order to conduct a frisk, you must also have a specific RAS that the person is armed, right? Armed and dangerous. So, a key thing there too with the new developments in concealed carry laws since the decision last year from the United States Supreme Court. We've had some pretty drastic changes in New Jersey when it comes to people carrying. So there again, not just that they're armed because they may be lawfully armed, but armed and dangerous, right? And so your RAS for the stop may or may not give rise to specific RAS that justifies a pat frisk. You may initiate a stop where the pat frisk would not be appropriate, but there is RAS for the stop. And then over the course of your investigation during that stop, you may develop RAS that would support a frisk. But it's important to know that they are two distinctly separate issues, and each must be supported by RAS.
And this is important for us to understand because the first thing that any defense attorney is going to go after is the initial stop. If the initial stop is unlawful, then the rest will be subject to the exclusionary rule, the fruit of the poisonous tree, decided federally under Matt versus Ohio. What we need to understand is, was this stop lawful? Where the attenuation doctrine comes in is for an unlawful stop, there was some sort of a break in the chain, a break in the activity that now separates the initial unlawful stop from what we have in front of us today. And that initial stop, even though it was unlawful, they're going to admit the evidence under the attenuation doctrine.
If I could jump in for 1 second, Joe, I just want to make a quick note here for any of the viewers that the attenuation doctrine doesn't apply only to those narrow circumstances where there's a stop or possibly a frisk, right? So that if I guess just to back up a second, what does that word attenuation actually mean, right? So if something is attenuated, it is reduced in value or force, right? And this is just right out of the dictionary, not necessarily being used in the legal context. And so in the legal context, the attenuation doctrine, what they're really talking about is there was some mistake, there was some constitutional trespass, if you will. The government, the police, somehow did something improper. That may be the stop, it may be the frisk, it could be some other thing that they did that led to evidence that evidence is now being challenged on some constitutional basis with an allegation that there was some misconduct on the part of the police, right? So it's not only applicable in that narrow set of circumstances with the stop and the frisk, but the cases we're going to look at and where you do see it most commonly is with a stop that is challenged.
So the first case we'll discuss briefly, just to get an understanding, is State versus Marcellus Williams. In this case, the defendant was subject of an unlawful investigatory stop. The defendant was obliged to submit to the investigatory stop regardless of the constitutionality, and instead the defendant physically resisted the pat down by pushing the officer's side and taking flight. In obstructing the officers, the defendant committed a criminal offense, which led to his arrest and discovery of the handgun incident to that lawful arrest. Obstructing the the police constituted a break in the chain from the unconstitutional investigatory stop, and the taint from that initial stop was significantly attenuated by the defendant's criminal flight that caused the handgun's later seizure, and accordingly, the application of the exclusionary rule was unwarranted. So under, and I see you have it written behind you there, Colin, but under State versus Williams, they gave us a three-prong test. There's the temporal proximity between the illegal conduct and the challenged evidence, the presence of intervening circumstances, and the flagrancy and purpose of the police misconduct. If you want to break those down one by one for us.
Right. So basically, what they're talking about here, number one, temporal proximity. What is that? It's essentially saying that there was some duration of time between the mistake made by the police and the actual seizure of the evidence that is being contested, right? And so, if enough time passes, it could be said that that temporal proximity is stretched out enough to diminish whatever the error was, and the influence of it on getting the evidence, right?
And a lot of the cases that we see with respect to pedestrians and the ones that we're going to go over today, they're very quick. And when they're
Right. You're
like
usually
that, they're
talking
going to
about moments that, and so typically, and the courts will evaluate each of these, by the way, each of these three factors, and they'll look at whether that factor weighs in favor of the government or in favor of the defendant who's trying to have the evidence excluded. And in many cases, what you'll see is that temporal proximity factor is going to weigh in favor of the defendant. We see that in Williams, and we see it in the other two cases we're going to look at in a couple of minutes here. But basically, what they're talking about there is the relationship in time between the mistake and the seizure of the evidence. Then you have intervening circumstances. That's what we see in Williams, right? So in Williams, where they initially conduct a stop that is not supported by sufficient RAS, right? That stop is then therefore improper. Okay, but what happens is there is case law that even if it is later determined that the initial stop is not supported by sufficient RAS, you still have to stop and comply. You can fight that later. You do not have a constitutional right to fight, to run, all that kind of stuff. And so that's exactly what happened with
and they very explicitly tell us they don't want court to be held on the side of the street.
Right. That's exactly
And
it.
truthfully, if you're the subject of an unlawful arrest, you're going to sue, you're going to be compensated. Your constitutional rights were violated. The place to do that is in a court of law, not on the side of the street.
Exactly. And I usually liken this to the motor vehicle stop, right? You pass a speed trap, you look down at the speedometer, and then the cop pulls out and you say, well, I don't have to stop because I wasn't speeding. But obviously you wouldn't do that, right? You would pull over and you would go along with the stop. And if you believe, that whatever they stopped you for, you were not guilty of that offense, then you go fight it in court. It's the same idea with the Terry stop, right? If you must still comply with the lawful orders of the officer. And so what happens here is resisting by flight, or obstruction by flight in this case, because he wasn't yet under arrest. So it's an obstruction charge in New Jersey under 2C. And so now he is subject to arrest for obstruction. And that is the attenuating circumstance. That is what breaks the causal link between the discovery of the evidence and the underlying mistake or misstep by the government, by the police. And so had he complied and they conducted a frisk and they found this firearm, it would have been thrown out because the stop and the frisk would not have been supported by RAS. It would have been fruit of the poisonous tree. But his flight, because it constituted that obstruction charge, and he is now subject to lawful arrest, that search incident to arrest, which yielded the firearm, they said that was totally lawful. And so that prong number two, factor number two, weighs heavily in favor of the government. And then number three, the flagrancy and purpose of the police misconduct. There, as we know, are some exceptions to some of these rules. For example, the public safety exception, right? You see this come up under Miranda and on occasion with frisks as well. And so here they're looking at, okay, was this a flagrant, blatant misstep. They knew that what they were doing was wrong and they shouldn't have done it. And we need to send a signal that this will not be allowed, and we're going to have to throw the evidence out? Or was this something where we're deciding months later in a court, we don't think you really had quite enough there to constitute RAS, and so we're gonna squash it. In this case, they said that the misstep, the mistake by the police, was not a flagrant one, and it was not their purpose to violate his rights or commit any kind of abuse. They were conducting what was a legitimate and lawful investigation. They just needed to do more to build up that RAS, and so that one.
They look at a
in this
lot at
case-
the subjective good faith, when it
Yeah.
comes to that
Yeah.
third prong. They want it to be that the officers were trying to act in the best interest of public safety, that they were acting in good faith, and not that he wasn't stopped based on race, he wasn't stopped based on religion. There
Right.
was no inappropriate police action that was flagrant against it.
Right.
Let's get on to this new case, relatively new. It's about a month ago. It's decided on April 24th, 2024. This is State versus Delshon Taylor. This is an appellate division unpublished opinion. November 15th, 2017, an officer reported hearing shots fired. He headed in the direction of the shots, and within moments, a 911 call came in reporting the shots fired in the area as well. Sergeant stopped 3 individuals. There was no description of any individuals involved in this case, and the sergeant candidly admitted she was not sure if the 3 individuals she stopped were involved. Several officers arrived, and the defendant stated he wanted to go home. He did not do anything, and he didn't have anything on him. This raised concern. The officers began to worry about safety. They told him not to leave. They were about to pat him down, and then the defendant took off running. Here enters our second prong. 2 officers chased after him. The defendant reached into his waistband, pulled out a handgun, and threw it on the pavement. He continued to run. The gun was retrieved. The officers discovered it was loaded with hollow point bullets. He was arrested and makes a motion to suppress. The court found here that the defendant's initial stop was an illegal investigatory stop. They did not have enough. This was goes into the last video we just posted about having a particularized description for a bolo. We can't just stop people that are walking in an area, even though there was a violent crime. We need to be able to connect them to that crime. The original shots fired didn't give any description of the individuals involved or any precise location. They were just in that area. So now let's examine that case through the attenuation doctrine, if you want to take that, Colin.
Yeah, so very, very similar circumstances to the case with Mr. Williams, right? So you have here officers conducting an investigation in relation to a firearm. Without going into too much detail about the fact pattern, you can certainly go and read the case if you like, but they just needed to do a little bit more to establish RAS. The court decided that they weren't quite there when they conducted the stop. And we see this a lot. In some cases, the officers, had they just written a better report and articulated a little bit more of the why behind what they were doing, the courts would probably rule differently. And so, in any case, it was determined later that they didn't quite have enough to rise to the level of RAS to support that stop. However, here again, when the subject takes flight, this now constitutes obstruction. Now he's subject to arrest. Now, the difference here is that they didn't get to the point where he's apprehended and now under arrest and conduct a search incident to arrest. In this case, as he's fleeing, as he's running from the police, he reaches into his waistband, grabs that gun, and throws it, and they recover it, right? And so now there's an even closer temporal proximity, right? Even though we're talking about seconds in many cases here, it's an even closer temporal proximity. So that does, here again, as it often does, it weighs in favor of the defendant who is the appellant, who is trying to have the evidence suppressed. But when you look at that second factor, right, that intervening circumstances, and they say here again, yeah, his flight was sufficient to basically break that causal link between the police misconduct and the discovery of the evidence. And he was not in any way compelled by the police to discard that firearm, right? That was something he did voluntarily. And so they said that this was sufficient under the attenuation doctrine that they would allow that evidence to remain.
And they specifically said in here as well that the judge found no evidence of any flagrant misconduct. They found the officers being credible. Body-worn camera footage corroborated the versions of the events. That's particularly important to understand as well. These justices are watching body camera video. They are taking testimony, understanding the reports, understanding what was put on record, and then looking at that body camera video. If everything matches up, that weighs in the favor of the state. So
I would just throw a quick point in there because body worn camera is something that I look at every day as part of my job function, and really want our cops to understand how important these cameras are, how helpful they are for us. So make sure you have it on. I mean, we could do a whole segment just on that, but also be careful not to be overly reliant on the BWC footage. And what I mean by that is don't take for granted that the judge or the attorneys or the jury that are watching that video later are going to understand everything that happened and that they're going to see what you saw, right? You can think of this like, if you're a football fan and you sit down and watch game film with, Eli Manning, right? You and he are not seeing the same thing, right? He's going to be seeing all kinds of subtle things on that film that you and I, as novices, are not going to pick up on, right? And it's very much the same thing when you watch police body worn camera footage. As professionals, we have to write a good report that walks somebody through that footage and explains, hey, the camera doesn't see everything that I see, and I don't necessarily see everything the camera sees, and we don't see it the same way. So walk them through what they're seeing on that footage and explain what things were important, what drew your attention, what you were focused on, what those things that you saw mean to you and why, based on your training and your experience, that they don't have. Don't just expect that they're going to watch it and understand everything that you understand as a cop.
absolutely. And just the last point on this case, the court said running with a loaded gun with a bullet in the chamber and then throwing it away were all acts that posed a risk to physical injury to police officers and members of the public. Defendants' intervening criminal acts broke the chain of causation between the unlawful stop and the seizure of evidence. The flight and intended actions were sufficiently attenuated from the stop to dissipate the taint of the unconstitutional action. Motion to suppress denied and appeal denied. All right, let's look at the next case, which is State versus Raheem Miller. This is decided May 28th, 2024, just a couple of days ago. It's Appellate Division, New Jersey, unpublished. The detectives in Camden discovered that a juvenile, TG, would be bringing an illegal handgun to a block party through social media. The court ruled that this was an anonymous tip. If you watched our last video, I went over a lot with respect to anonymous tips. The detectives stopped a group of 4, including TG. 2 of the individuals ran. A secondary detective was looking for the individuals that ran. He observed a male wearing a gray sweatsuit walking out of an alleyway about 100 feet from where the initial attempted stop occurred, that the defendant had the hood of his sweatshirt over his head, hands in his pockets. The detective believed that it was incompatible with the warm weather. The defendant walked directly towards the detective. The detective radioed his supervisor to get a better description of the males in case he was part of the group that had run from the earlier stop. There is no indication that the defendant tried to avoid the detective. As the defendant drew close, he asked, "You all right, buddy? You all right?" The detective grabbed defendant's arm with one hand and put his other hand on the defendant's chest. The defendant told D, "Your heart is pounding, bro. The second that any force is exhibited upon a defendant, that is a constitutional seizure." So at that point, there is now a seizure. The detective noticed a large bulge under his sweatsuit. While holding his arm, he said, "Don't move." There was a brief radio transmission, told him to put his hands behind his back. The defendant was 28 years old and was not one of the 3 juveniles that they observed earlier walking with TG. The defendant or the detective at that point said that the bulge was a large bulge. He had a sweatsuit which wasn't corresponding with the weather. And at that point, he was unable to confirm exactly who ran from the area. So at that point, I believe he was possibly armed and dangerous and involved. The detective tried to secure him by putting his hands behind his back. He did not comply and tried to pull away from the detective's grasp. While the detective held his sleeve, the defendant took his sweatshirt off. As the sweatshirt was coming off, the bulge was revealed to be a fanny pack. About 6 seconds later, the defendant tried to pull away. From the first time that he tried to pull away, the detective pulled him close, held him from behind in a bear hug. He struggled for about 24 seconds. The defendant reached into a fanny pack, removed the gun, threw it on the sidewalk. The police recovered the gun lying on the sidewalk. So now we have to examine this case through the exact same factors. They quote State versus Williams with respect to our attenuation doctrine. If you want to
Right.
take that.
Right. So, a couple of things with this one. So, number one, interestingly, I think when we talk about temporal proximity, going back to the issue of RAS, right? This, and I'm going to tie this into our third factor. Okay, this is a prime example of a situation where the police were acting in good faith and believed that they had RAS, and the courts later decide that they didn't. And any judge in any other courtroom may have arrived at a different conclusion. When you look at the physical and temporal proximity of this subject to the original stop where the two suspects fled, right? He is something like 100 feet away, and only seconds after they fled when this detective sees him coming out of the alleyway. That, coupled with the sweatsuit on during the warm summer months with the hood pulled up, combined with the fact that this was in a high crime area in Camden. All of these factors, and he's sweating. He appears to be nervous. When the officer, tries to speak to him, he's looking away. All of these different factors combined, I would think that this would rise to the level of RAS, right? And given what the original stop was for, that they suspected them of carrying a gun or guns and going to carry out an attack based on this intel from social media, that RAS for the stop would also give rise to RAS for the Terry frisk. Okay. However, court later on decides they lack the RAS for the original stop of this gentleman. So be it. Now we go to the attenuation doctrine. We look at those factors. Here again, temporal proximity. This was, we talked about, what was it, about 30 to 40 seconds from when he originally put his hands on him to when the firearm is produced. So it happened very quickly. So here again, we see this weighs in favor of the defendant. Intervening circumstances, though, much like the other cases, his resistance, in this case, fighting, struggling, attempting to get away, is going to constitute that attenuation that breaks the causal link, breaks the chain between that unlawful stop and the discovery of the evidence that he's seeking to have suppressed. And then lastly, when we look at the flagrancy and purpose of the misconduct, here again, they look at this and accept that the officer was acting in good faith. He wasn't trying to violate anybody's rights or anything like that. And any court could have arrived at a different decision as to the RAS for the underlying stop. And so here, the bottom line is the evidence was allowed in under this attenuation doctrine.
And especially being that this is an unpublished opinion, one of the important things to understand is that there's several different judges that are on panels for the appellate division. You may have one panel agreeing with the fact that this did have RAS for the stop, and this panel clearly said it wasn't. It's unknown at this point if this will be appealed to the Supreme Court. However, the fact that this was the evidence was admitted, I don't think that they're going to push this case much further on the state's level, being that they're not even challenging the initial stop. They're looking at this through the eyes of the attenuation doctrine. And one thing I will also say as a caveat is that third prong is so important to us. I would never, as an officer in the street or a supervisor reading a report, look to use this as part of my reasoning or probable cause. This is something that comes in after the fact. This is something that comes in later when we find that we didn't have enough RAS. So that third cause, we're making sure that we're acting in good faith and making sure that we're doing everything by the letter of the law. I'm confident that these officers, like you said, when they made that initial stop, they thought that they were doing the right thing and trying to get a gun off the street. They were trying to protect the innocent civilians that were going to be at this block party. So I think that that's a caveat worth bringing up. That's just to bring the case to conclusion. Even accepting for the sake of argument, detectives' Fourth Amendment violation was flagrant. The intervening act under the second prong was so alarming as to justify invocation of the attenuation exception. Clearly, reaching for and handling a concealed handgun while grappling with an officer, even if only to discard it rather than fire it, cannot be tolerated and must be deterred. Appeal denied. Well, thank you everybody for joining us in this roll call. Looking forward to doing more. Stay safe.